Thanks to all who have dialed into the teleconference for standing by. Welcome to the open meeting of the Public Company Accounting Oversight Board. During the call, you'll be in listen-only mode. If you should require technical assistance from AT&T Teleconference Services, please press star, then 0. As a reminder, this meeting is being recorded and a recording is expected to be made available on the PCAOB website. I would now like to turn over the meeting to Chairman Dunkey to formally convene the meeting.
Good morning and welcome, everyone. This is an open meeting of the Public Company Accounting Oversight Board on May 13th, 2021. We welcome you who have joined us today by dialing into the teleconference or listening to the webcast of this meeting. Today, the board will consider a staff recommendation that we propose for public comment, a new rule to govern our responsibilities under the Holding Foreign Companies Accountable Act. The statute requires the board to determine whether it is unable to inspect or investigate completely registered public accounting firms located in a foreign jurisdiction because of a position taken by one or more authorities in that jurisdiction. Before we proceed with the agenda, I'll note for the record that all board members are participating in this meeting and are able to hear one another. To present the staff's recommendation on the proposed new rule, I'll turn to our General Counsel, Mr. Ken Lynch. Over to you, Ken.
Thank you. Good morning, Chairman Dunkey and board members. As you know, the Holding Foreign Companies Accountable Act, or HFCAA, became law in December 2020. The HFCAA calls for the board to determine whether the board is unable to inspect or investigate completely registered public accounting firms in a foreign jurisdiction because of a position taken by authorities in that jurisdiction. As discussed in the memorandum before you, the Office of the General Counsel recommends that the board issue for public comment a proposing release for new PCAOB Rule 6100 board determinations under the Holding Foreign Companies Accountable Act. The proposed rule would provide a framework for the board to use when making determinations under the HFCAA. Before the Office of the General Counsel presents the recommendation, I would like to invite Liza McAndrew Mooberry, the Director of the Office of International Affairs, to offer some introductory remarks.
Thank you, Ken. I would like to thank you and your team in the Office of the General Counsel, with special recognition to Drew Dropkin, as well as our colleagues from other offices and divisions, for collaborating with the Office of International Affairs in developing the recommendation before the board today. Good morning, Chairman Dunkey and board members. Fair and transparent markets in which investors can rely on the consistent application of rules facilitate the efficient allocation of capital. The Sarbanes-Oxley Act addresses one aspect of consistency that brings us here today, a level playing field with respect to oversight of firms that audit the financial statements of U.S. issuers. The Sarbanes-Oxley Act directs that any foreign public accounting firm that prepares an audit report with respect to an issuer shall be subject to the Act and the rules of the board in the same manner and to the same extent as a firm located in the United States. In other words, the Act provides that the board's obligation to oversee a registered firm do not depend on the firm's location. Rather, its oversight is triggered by the firm's decision to serve as the auditor of a U.S. issuer. The nature of that oversight is mandated by Congress and includes board inspections and investigations. The board must periodically inspect firms that issue audit reports for U.S. issuers. During those inspections, board staff must obtain documents and information so that it can review audit engagements and quality control systems and perform other procedures. The board also is authorized to conduct investigations of potential statutory, rule, and professional standards violations by firms and their associated persons. To facilitate those investigations, the board can require testimony and the production of documents. Together, inspections and investigations are crucial aspects of board oversight. Congress recently reinforced the requirement under the Sarbanes-Oxley Act for a level playing field. The Holding Foreign Companies Accountable Act requires the Securities and Exchange Commission to take certain actions with respect to issuers that retain a registered public accounting firm located outside of the United States that the board determines it is unable to inspect or investigate completely because of a position taken by an authority in the foreign jurisdiction. In a moment, my colleagues in the Office of the General Counsel will provide details of a staff-recommended rule addressing the board's responsibility under the Act. Before turning to them, I would like to thank my colleague in the Office of International Affairs, Beth Hilliard-Collet, for her work on this project and ask her to address the board's long-standing practice of recognizing the unique situations that can arise with respect to oversight of registered firms located outside of the United States and the cooperative manner in which the board has consistently sought to address conflicts. Beth?
Thank you, and good morning. As mentioned, the board has long observed that certain aspects of its inspection and investigation mandates may raise special considerations for non-U.S. firms, including potential conflicts with non-U.S. law and other obstacles. To address these, the PCAOB has, since its inception, invested in developing a cooperative framework with regulators that is built on a foundation of trust, candor, and a mutual interest in protecting investors. Where needed, the board has pursued cooperative arrangements with international counterparts to facilitate cross-border oversight. The board has benefited from robust, long-standing relationships characterized by two-way communication, constructive problem-solving, and a dedication to independent audit oversight. The board's cooperative approach to oversight of PCAOB-registered firms located outside the United States has not entailed any abandonment of the board's inspection or investigation mandates or any relinquishment of the board's statutory authority. Instead, the board has worked successfully with its international regulatory counterparts based on norms of international comity to maintain a consistent approach to oversight of all registered firms, whether located in the United States or abroad. International comity simply means a mutual respect for each other's mandate, finding protocols and practices whereby each jurisdiction's mandate is facilitated and neither mandate is diluted or compromised. The PCAOB has always been transparent about the requirements of its statutory mandate. No matter where a firm is located, we must conduct inspections and investigations consistent with the Sarbanes-Oxley mandate. We must be able to select the U.S. audit work for review or investigation. And we must have access to the audit-related information we deem relevant. In some cases, negotiations to address legal obstacles and sovereignty concerns have been protracted, impeding the board's ability to conduct inspections and investigations of certain non-U.S. firms. In response, the board began publishing and still maintains on its website information so that investors are aware of those jurisdictions with registered audit firms for which the PCAOB statutory mandate to conduct inspections is overdue. I will now turn back to Ken.
Thank you, Liza and Beth. The Office of the General Counsel is grateful for the opportunity to collaborate with the Office of International Affairs regarding the proposed rule. I also would like to thank the attorneys in my office who worked on this initiative, and I particularly want to acknowledge the contributions of John Cook, Drew Dropkin, and Damon Andrews. Senior Associate General Counsel Drew Dropkin will now present the recommendation.
Thanks, Ken. Good morning, Chairman Dunkey and board members. Today, the Office of the General Counsel presents for the board's consideration a recommendation to issue for public comment a proposing release for new PCAOB Rule 6100 entitled Board Determinations under the Holding Foreign Companies Accountable Act. As already noted, the HFCAA calls for the board to determine whether it is unable to inspect or investigate completely registered public accounting firms in a foreign jurisdiction because of a position taken by authorities in that jurisdiction. The HFCAA does not, however, specify the procedure the board should follow when making such determinations. Nor does the HFCAA expressly require the board to adopt a rule governing that determination process. Nevertheless, the Office of the General Counsel believes that such a rule would inform investors, registered firms, issuers, audit committees, foreign authorities, and the public at large as to how the board will perform its functions under the HFCAA. Furthermore, such a rule also will promote consistency in the board's determination process. Proposed Rule 6100 was drafted with those potential benefits in mind. The proposing release discusses the proposed rule in detail. My presentation will be limited to a brief discussion of the central features of the proposed rule. To start, the proposed rule provides for two types of determinations that the board may make. First, the board may make determinations as to a particular foreign jurisdiction. If a foreign authority articulates or maintains a position that applies generally to PCAOB inspections or investigations in its jurisdiction, that position could provide the basis for a jurisdiction-wide determination by the board. Under the proposed rule, a jurisdiction-wide determination would apply to all registered firms headquartered in the jurisdiction. Limiting jurisdiction-wide determinations to firms that are headquartered there is intended to ensure that such determinations are appropriately tailored and do not encompass firms that merely have a physical presence of any kind or personnel of any number in the jurisdiction. Second, complementing the board's ability to make jurisdiction-wide determinations, the board also may make determinations as to a particular registered firm. Such determinations can serve two purposes. First, a determination can be made as to a particular registered firm if a foreign authority obstructs a board inspection or investigation of that firm, but does not obstruct inspections or investigations in a more general manner that would apply to all firms in the jurisdiction. Second, a determination as to a particular registered firm can supplement a jurisdiction-wide determination. As just noted, a jurisdiction-wide determination would be limited to firms headquartered in the jurisdiction. But if the foreign authority's position also impairs the board's ability to inspect or investigate firms that have an office in the jurisdiction but are headquartered elsewhere, the board, under the proposed rule, could make determinations as to those firms as well. Under the HFCAA, the board's determinations turn on whether the board can inspect or investigate completely. The HFCAA, however, does not define inspect or investigate completely. The proposed rule would tie the board's ability to inspect or investigate completely to the board's mandate with respect to inspections and investigations set forth in the Sarbanes-Oxley Act. Specifically, when making determinations under the proposed rule, the board would assess whether the position taken by the foreign authority impairs the board's ability to execute its statutory mandate with respect to inspections or investigations. That assessment is driven under the proposed rule by three factors. The first factor is the board's ability to select engagements and audit areas to be reviewed during an inspection and to select potential violations to be investigated. The second factor is the board's access to and its ability to retain and use any document or information in the possession, custody, or control of registered firms or their associated persons that the board considers relevant to an inspection or investigation. The third factor is the board's ability to conduct inspections and investigations in a manner consistent with its statutory mandate and the rules of the board. This third factor captures all of the other aspects of the board's statutory mandate that are not already subsumed in the first and second factors. That includes, among other things, the board's ability to satisfy inspection frequency requirements and to share information with the Commission and other regulators. These three factors are not separate prerequisites for a board determination. Rather, if the board's ability to execute its statutory mandate is impaired in any one of these three respects, a board determination can be warranted under the proposed rule. Moreover, when looking at these factors, the board need not be impaired as to both its inspections and its investigations. The board may make a determination under the proposed rule if it is unable to either inspect or investigate completely. In addition to identifying the factors that the board would evaluate, the proposed rule also describes the documents and information that the board could consider when making a determination. In this regard, the proposed rule provides that the board may consider any documents or information it deems relevant. The proposed rule nevertheless identifies, for the avoidance of any doubt, certain categories of documents and information that the board may consider. The proposed rule also provides that a board determination need not depend on the board's commencement of the inability to complete an inspection or investigation. This provision acknowledges that foreign authorities' positions can make it impossible or infeasible as a practical matter for the board to attempt to commence an inspection or investigation in a foreign jurisdiction that rejects the guiding principles for international cooperation. The proposed rule also addresses the timing of board determinations. The proposed rule provides that if a final rule is adopted by the board and approved by the commission, the board would make any determinations that are appropriate under the rule promptly after the rule becomes effective. Thereafter, the board would consider, at least annually, whether changes in facts and circumstances support any new determinations under the rule. If the board, as part of that annual consideration or otherwise, concludes that new determinations are appropriate, the board would make such determinations when appropriate to allow the commission, on a timely basis, to identify covered issuers as contemplated by the HFCAA and pursuant to the commission's rules. Under the proposed rule, when the board makes a determination, the board's determination would be issued in the form of a report to the commission. The board's report would describe the board's assessment and the basis for the board's determination, and also would identify the firms that are subject to the determination. Promptly after the board's report is issued, a copy of the report would be made publicly available on the board's website, subject to certain confidentiality limitations. Under the proposed rule, a board determination would become effective on the date the board issues its report to the commission, and that determination would remain in effect until it is modified or vacated by the board. Under the proposed rule, after the board issues a determination, it would consider, at least annually, whether changes in the facts and circumstances supporting that prior determination merit a reassessment of the determination. Apart from that annual process, the board also can reassess a prior determination on its own initiative or at the commission's request at any time. When reassessing a prior determination, the board would reevaluate the factors, and based on that reevaluation, the board may modify or vacate its prior determination or leave it in place. The Office of the General Counsel believes that issuing this rule proposal for public comment would enable the board to obtain feedback from stakeholders regarding the proposed rule before the board adopts a final rule. The proposing release would solicit comment on all aspects of the proposed rule, including the economic analysis conducted by the Office of Economic and Risk Analysis. The proposing release also poses a number of specific questions for public comment. The Office of the General Counsel recommends that the board provide a 60-day period for comment through and including July 12, 2021. For the foregoing reasons, the Office of the General Counsel recommends that the board issue for public comment the proposing release for new PCAOB Rule 6100, board determinations under the Holding Foreign Companies Accountable Act, in substantially the form attached to the recommendation memorandum before you. In closing, I want to recognize the valuable contributions of staff throughout the organization. In particular, I want to thank my colleagues in the Office of the General Counsel, especially Ken Lynch, John Cook, and Damon Andrews. I also want to thank Liza McAndrew Moberg and Beth Hilliard-Colley in the Office of International Affairs, Nayantara Hensel, Michael Gervit, Rashawn Inget, and Tian Liang in the Office of Economic and Risk Analysis, David Hardison in the Office of the Chief Auditor, Polly Jans in the Division of Registration and Inspections, and John Abel and Bill Ryan in the Division of Enforcement and Investigations for their efforts. Finally, I want to thank the Commission staff for their support and assistance. We would be glad to answer any questions. Thank you.
Okay, Drew, thank you very much. Thank you much, Ken, Liza, and Beth, for your overview of the rule. Appreciate it very much. Very well done. We'll turn now to board member statements, and then we'll proceed in order of seniority before we proceed to consideration of the rule itself. And we'll begin with my statement. The U.S. capital markets are and have long been the envy of the world. Companies that seek access to capital list securities in the U.S. because of the strength and consistency of our markets. That strength and consistency comes from many features of our system. Among the defining features is that our system promotes access to high-quality, reliable financial statements audited by independent auditors. Recognizing the importance of audit quality to our capital markets, Congress created the PCAOB. It specifically assigned the organization a mission, the purpose of which is to protect the interest of investors and further the public interest in the preparation of informative, accurate, and independent audit reports. The PCAOB accomplishes that mission consistent with Sarbanes-Oxley by performing three main oversight activities. First, we set auditing standards and related rules for audit firms to follow. Second, we inspect registered firms' compliance with those auditing standards and related rules. And third, we investigate potential violations of our auditing standards, rules, and securities laws, and where appropriate, discipline registered firms and their associated persons for violations. Given the global nature of our capital markets, our oversight activities necessarily extend beyond our own borders. Consistent with our statutory mandate, we seek to inspect and, where appropriate, investigate and discipline PCAOB registered firms regardless of the jurisdiction where those firms are located. Currently, there are 1,727 PCAOB registered firms. Of those firms, 853 are located in 90 separate jurisdictions outside of the U.S. 298 of the firms located outside of the U.S. perform activities requiring registration with us, and those firms are located in 62 jurisdictions. For the 12-month period ended March 31st, 2021, PCAOB registered firms located outside of the U.S. issued 1,166 audit reports on issuer financial statements. Those issuers had a combined market capitalization as of March of this year of more than $11 trillion. Over the years, the PCAOB has achieved remarkable success in executing its oversight role across the globe. That success is due in no small part to the immense cooperation we've received from numerous foreign regulatory authorities. We've been fortunate over the years to forge strong bilateral relationships with regulatory authorities that, like us, are dedicated to promoting high-quality financial reporting and audits. Such authorities, where required, have worked side by side with us to ensure that we can accomplish our oversight mandate in their jurisdiction, including by providing us with the access we need to conduct inspections and investigations. Together with our international partners, we share a vision that international cooperation strengthens audit quality globally. International cooperation, unfortunately, has not been uniform, and thus an unlevel playing field currently exists. To address this issue, Congress recently passed and the President signed into law the Holding Foreign Companies Accountable Act. The statute vests the PCAOB with the responsibility of determining whether it is unable to inspect or investigate completely registered public accounting firms located in a foreign jurisdiction because of a position taken by an authority in that jurisdiction. The rule we propose today provides a framework to guide the board in carrying out its responsibility under the statute. The draft rule sets forth the specific factors that the board proposes to consider when weighing whether it is unable to inspect or investigate completely, as required by the statute. These three factors are not new. Rather, they represent the very foundational principles on which all of the board's cooperative agreements with foreign authorities are based. These principles articulate the basis on which we determine whether we have the access we need to perform inspections and investigations consistent with our mandate under the Sarbanes-Oxley Act. The remainder of the rule sets forth the manner in which the board will make its determinations, the form, public availability, and duration of the board's determinations, and the process by which the board can modify or vacate its determinations. Although the statute does not mandate that the board issue a rule to govern the determinations it is required to make, I strongly support issuing a rule. A rule will promote transparency into the board's processes and will ensure consistency over time in how the board exercises its judgment in applying the statute. To ensure the board considers all relevant facets of the proposed rule, we are seeking public comment. We hope that our stakeholders, and in particular investors, will weigh in on the proposed rule and provide us with their insights. We greatly look forward to receiving and reviewing your comments. I fully support today's recommendation and urge its adoption. In conclusion, thanks to all the staff members who assisted us in getting this point, particularly our staff in the Office of General Counsel and the Office of International Affairs. I'd also like to thank the staff of the SEC who has worked so closely and collaboratively with our staff during this process. By any measure, this has been accomplished under a very demanding timeline. And it just goes to show what can be achieved when our two organizations work cooperatively and constructively toward a common goal. I'll turn now to my fellow board members for any remarks they wish to make, starting with Board Member Desparty.
Thank you, Bill. And I too support our seeking public comment on the proposing release as set forth before us today. You know, as you've heard, robust inspections and investigations of registered audit firms that audit U.S. public companies are core to our mandate under the Sarbanes-Oxley Act, and that's whether such firms are located in or outside the U.S. Through passage of the HFCAA, Congress has reaffirmed the importance of our oversight activities in providing protection for all investors of U.S. public companies, regardless of where audit firms are located or audits are performed. If ultimately adopted, the proposed rule would establish a framework for the determinations that we are required to make under HFCAA, helping to promote consistency in our determinations over time and providing transparency to investors, firms, issuers, and other market participants as to the factors the board would consider and the process that the board would use in making its determinations. While the proposed rule provisions are well informed by what you've heard this morning, our long history of constructive cross-border cooperation with virtually all of our foreign counterparts, in the release we are seeking input on a number of elements of the proposed rule. I encourage investors, firms, issuers, and other key stakeholders to provide us your feedback. I am particularly interested in perspectives as to whether the proposal provides sufficient transparency of and sufficient timely reassessments of the board's determinations. And as a reference, these topics are addressed in Section 3D2 and Section 3E of the release. In closing, I want to recognize and thank all of those who have contributed to developing today's proposal, including our colleagues at the SEC, and with special recognition of our PCAOB staff in the Offices of International Affairs, Economic and Risk Analysis, and General Counsel. Thank you, Bill. I'll turn it back to you.
Thanks, Dwayne. Board Member Gosharan-Jurata.
Thank you, Mr. Chairman. First, I would like to thank all of the PCAOB staff who worked so diligently to draft this proposed rule in response to Congress's mandate and the Holding Foreign Companies Accountable Act. Today's proposed rule is the result of a remarkable collaboration between our General Counsel's Office, the Office of International Affairs, the Office of the Chief Auditor, the Office of the Economic and Risk Analysis, and representatives from the Division of Enforcement Investigations and those from Registration and Inspections. We also appreciate the SEC staff's assistance that was offered to us as our dedicated staff worked to prepare what is being recommended to the board today. Everyone who worked on this project is to be congratulated and commended. Specifically, I want to express my gratitude to Ken, Liza, Beth, and Drew for presenting the recommendation today. I am pleased to support the proposal of this rule for public comment. The PCAOB's mission is to protect investors and further the public interest in the preparation of informative, accurate, and independent audit reports. In executing that mission, the PCAOB plays a critical role in the U.S. capital markets. I believe that in order for investors, for example, to save for retirement and college tuition through our capital markets, they must be able to trust that the information that is provided to them is accurate and that they can rely on issuers' financial statements. High-quality audits and the PCAOB's regulation of auditors are critical to that reliance. For too long, there has been a gap in the PCAOB's ability to inspect and investigate completely auditing firms located in some foreign jurisdictions. Inspections and investigations are the main mechanism through which the PCAOB execute its important mission. For the protection of investors, all firms performing issuer audits should be subject to our inspections and investigations without interference from foreign authorities. Investors should be able to rely on the financial statements of issuers traded in the United States, regardless of where the issuer's audits take place. My hope is that the Holding Foreign Companies Accountable Act will help the PCAOB close the gap in its ability to inspect and investigate foreign firms and help us to fulfill our mission to protect investors. The PCAOB has successfully worked with foreign regulatory authorities in most jurisdictions to enable the PCAOB to complete inspections and investigations, and we look forward to continuing those cooperative relationships. The HFCAA and this rulemaking aim to address instances where foreign authorities have interfered with or limited the PCAOB's ability to inspect and investigate firms. The PCAOB's inability to inspect certain firms has been to the detriment of investors, and I support Congress's work to address these problems. As Drew has already discussed, the HFCAA requires the PCAOB determine whether it is unable to inspect or investigate completely registered public accounting firms located in foreign jurisdictions because of a position taken by one or more authorities in that jurisdiction. Today's proposed rule sets out the mechanism for the PCAOB to make its determinations. I believe it is important to formalize the determination mechanism in a rule to promote transparency and consistency. The HFCAA and its proposed rule represent a new approach that has not been tried before, and so receiving feedback on this proposed rule from our stakeholders is especially important. The HFCAA was passed on a bipartisan basis and provides needed protections for investors. I want to ensure that we are responding to Congress's mandate in the best way possible. I strongly encourage you to comment on all aspects of the rule, including the questions posed in the release. I would also like to draw your attention to several aspects of the proposed rule where your feedback would be particularly helpful. First is the frequency of the board's determinations and whether you believe the combination of periodic and ad hoc determinations provides sufficient flexibility and predictability to offer fair process to stakeholders and to allow the board to fulfill its mission. Second, the process of notifying firms that the board has determined it is not able to inspect or investigate them completely, and whether you believe the process as currently described is sufficient. Third, the duration of board determinations. Fourth, whether the rule should provide the board with acceptive and or exemptive powers. And lastly, whether there should be a process for requesting that the board reconsider its determinations, and if so, what that process should be and when it should take place. To conclude, this is an important rulemaking, and I am proud to be a part of it. I thank you in advance for your thoughtful comments. And thank you, Mr. Chairman.
Thanks, Rebecca. Board Member Zietsman.
Thank you, Mr. Chairman. I'm very pleased to support the proposed new rule that is the subject of today's recommendation. The proposing release sets forth useful background information regarding the board's statutory inspection and investigations mandates, including how over the years, and as it relates to registered firms located outside the United States, the board has worked effectively and cooperatively with authorities in most foreign jurisdictions to fulfill this mandate. The release also describes the core principles that underpin the practices and approaches that the board has developed with foreign regulators to resolve conflicts to enable completion of inspections and investigations in accordance with the board's governing statute. However, positions taken by non-U.S. authorities in certain jurisdictions impede the ability of the board to discharge its mandate. Against this backdrop, and as we've heard discussed, the Holding Foreign Companies Accountable Act was signed into law. This act imposes obligations on the PCAOB to make determinations regarding its inability to inspect or investigate completely registered public accounting firms located in a foreign jurisdiction because of a position taken by one or more authorities in that jurisdiction. The HFCAA also mandates the actions the Securities and Exchange Commission should take after the board makes such a determination. The HFCAA does not, however, set forth the processes for the board to follow in making these determinations. The proposed rule is therefore important because it would establish the facets of the board's determination process, which in turn form the basis for both the board's compliance with and the SEC's implementation of the HFCAA. The proposed rule would also provide transparency as to how the board will perform its functions and promote consistency in its determination processes. I encourage interested parties to read the release and respond with their views and comments about the matters that the board should consider in preparing a final rule. The release contains a number of questions that address matters where we would in particular like to hear the perspectives of our stakeholders. Of course, commenters need not answer every question and are welcome also to comment on other matters. I would like to thank all the PCAOB staff from the various divisions and offices who have worked very hard and thoughtfully to expeditiously progress this rulemaking. We'd also like to thank the staff of the Securities and Exchange Commission for their valued input and perspectives. Thank you, Mr. Chairman.
Thank you, Megan, very much. All right, I'll just pause for a moment, see if there's any further discussion from the board. And if I'm hearing none, we'll move to a vote. Hearing no further discussion, I'll ask all those in favor of approving the recommendation to say yes, yes,
yes,
yes. Any opposed, please say no. Hearing no votes, I'll presume that the vote was unanimous and the recommendation is approved. And that concludes the PCAOB's open meeting for today. If there is no further business, this meeting is now adjourned. Thank you for your participation, and you may now disconnect from the teleconference. Have a good day.